There we go. Hey guys, I'm going to share the screen because the attorneys are in the courtroom. I was sitting at my desk, so it was perfect that I was already here. Let me put the, I didn't think it would take them long. And I'm hoping that they actually have a verdict and not just a question. Because Lord knows. Yep. Hey, Cynthia. Hey, John. Hey, Flash fan. So 1:30, I was kind of right. I originally said 1:30 and then I set it up for 2. Hey, Tammy. Because I'm like, it'll allow me to get stuff done in the house. Hey. So I sort of got a slice of pizza scarf down. And I'm going to turn off my camera for a minute because I'm going to get a drink. I hope she gets to have a sweet 16 in prison. You know. Can anybody tell me how I'm sounding? Because I changed the settings on my audio and turned my audio down a little bit to try to match the court. Oh, there's the creeper himself. I told you it wouldn't be very long, but they did have to eat lunch somewhere in there, so. Okay. Because I was rewatching some of the stuff from earlier, and it was like, I was really loud compared to the court, so I had it set where this is where I shouldn't have trusted. I shouldn't have trusted StreamYard to do anything because I had it where they automatically adjusted the volume compared to what it was playing. And I think she's going to be guilty. Okay, I'm just making sure my audio's on because she's already crying and she hasn't even seen anything. Now I think these are real tears because the shit's no longer I'm accused of something. It's here we go. So does anybody have audio on another let's go. I'm gonna check not long crime. Hey Denise, how are you? I'm gonna check Court TV and see if they have sound, because we've had problems with both. Okay, it sounds like Court TV has. We're gonna go to Court TV this time. I'm gonna share this tab. But apparently nobody else has sound either, so it's not just me, it's not just us. I'm thinking she's crying because she I'm crying. I think she's crying because she actually knows she's effed. This is the only time that I actually believe her tears because notice there's no like dry heaving, there's no like like she knows that she's screwed. So I just can't I can't fathom that she thinks she's gotten away with this. So in the poll for court TV. They're up to like 9,200 votes. 82% say guilty. I'm okay. Like, I've had my moments where I get a little emotional, but overall I'm pretty like, it is what it is and it can't really do much. I feel more upset for my dad than I do for myself, but just because my dad's having to deal with all this stuff, and luckily one of my friends, Jeremy, is helping my dad with stuff. So I think it's Friday. It might be your birthday. Is it your birthday, John? 1 hour and 57 minutes. Yeah, I told you, didn't I tell you it would be 2 hours or like, something close to that? I jokingly said it would be a half an hour longer than it took them to fill out the jury forms, but I forgot they had to eat. Happy birthday. I remembered. Sort of. I sort of remembered. I remembered with a kind of a reminder. Everybody in the chat say happy birthday to John. He's now officially older than me for another 5 days. This is where John actually gets to be a number older than me. I always joke with Mr. Squid that he's 2 years older than me, but he's really only a year and a half. But he, for that 6 months, I get that, 2-year age gap. If I had a song for you, I'd play it, but you don't want to hear me sing happy birthday because I would blow out your eardrums and potentially, like, make you... Here we go!
All right, please be seated.
You don't know why I'm nervous.
The court's been informed that the jury's reached a verdict. I say this in every case. One half of this room, I don't know which half, is going to be upset. Do not add injury to insult. These people did not ask for this job. They didn't want the job. The state and the defense forced them into the job. You will not approve the jury's verdict, and you will not disapprove of the jury's verdict, or you will go to jail. There's a 30-day jail sentence for every outburst. I'm going to give anyone who does not believe that they are able to control their emotions the opportunity to leave the courtroom at this time. Would anybody like to leave? All right, Mr. Bailiff, please bring in the jury.
Mississippi don't play. I mean, Mississippi really don't play. Yeah, Judge Arthur is not somebody that I'd ever want to be on the wrong side of. I like him, but that's because I didn't do anything wrong. Oh. Yeah, I say guilty too. I mean, I don't know. Anything could happen though. Remember that. Like, juries are unpredictable.
You can sit right there, ma'am. Ma'am, I see you're holding some papers. The jury been able to reach a verdict in any of these counts. All right, if you would, please hand the paper to the bailiff. Ms. Gregg, please rise and come to the podium, along with your attorneys.
She looked at her family.
Verdicts appear to be in proper form. Verdict of the jury is count 1. We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count 2. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count 3. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg. Ladies and gentlemen, the jury is custom for the court to poll the jury. I have to do it each time. And for each count, I'm not being rude. The quickest way for me to get through this is to simply point at you and you answer out loud. As to count 1, we, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? You got to answer out loud, ma'am. I'm sorry. On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? That verdict is proper and unanimous. As to count 2, we, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Count 3, we, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Beginning on the first row, ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? On the back row, sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? All right. All 3 verdicts appear to be unanimous. The court will enroll the verdict. All right, ladies and gentlemen, with you having returned a verdict of guilty in count 1 and count 2 of the indictment, we'll now proceed to the sentencing phase of the trial. State of Mississippi may call its first witness.
Your Honor, the state has no witnesses. We would just ask that the court adopt the previous testimony that the jurors have heard, with the exception of we seek to introduce 1 photograph.
All right. State wishes to move to adopt and incorporate by reference the record of the guilt phase. Is that correct? Show your piece of evidence to the other side. Any objection?
Yes, Your Honor.
Remember when I said I get emotional when there's real emotion? Like, I'm emotional for her. That's how I know it's real emotion. Yeah, Mississippi don't play flash fan. Get down, please. Ma'am, get down. Get down. Thank you. Wait, one. She like try to. We're in the. She does not like to be told no, and she keeps hopping up on the side of her standing tower, and she's going to knock it over and fall on her head. So when I lift her out of it, she gets pissed. Oh, thank you. It's a workout top. I plan on when I started streaming this morning, it was 65 degrees outside. It is currently 85 degrees at my house. So a sweater or a long sleeve shirt was no longer applicable. I wonder what they were objecting to. And I wonder what the evidence is. See, this is real emotion. So when someone has real emotion, I get emotional. Like, so when her tears were fake, I didn't feel a thing. And now that like I see her actually crying in real tears, like realization that she's never going to be free.
To adopt and incorporate by reference the record of the guilt phase of the trial. The court will grant that request. Does the state have any other witnesses it wishes to call?
No, sir.
All right, defense may call any witnesses.
Adult crime, adult punishment. Like, when you take somebody else's life, you no longer become, right. You're no longer a child.
The defense not calling any witnesses, attorney's approach. Does the defense rest its case in chief as to sentencing? Do you also move to adopt and incorporate by reference the record? All right, y'all approach.
Yeah. Yeah, I want to think that it was just a stupid mistake, but I don't think that it was. The video to me showed calculation, that she knew what she was doing and she did it anyway. And then when she did it, she wasn't like, oh crap, I did it, like a crime of passion. Oh my God, what'd I do? She tried to take out her other parent. Like, yeah, that's true. This is real emotion. Her tears during the trial and on that first day.
All right, ladies and gentlemen of the jury, with both sides agreeing to rely on the testimony from the guilt phase, the court will further instruct you at this time. You, the jury, have found the defendant guilty of the crime of first-degree murder in count 1. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family, home, and environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for first-degree murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, your verdict will be as follows. Quote, count 1. Quote, as to count 1, we, the jury, sentence the defendant, Carly Gregg, to life imprisonment. Close quotes. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count 1, we, the jury, sentence the defendant, Carly Gregg, to life imprisonment with the possibility of parole. Close quote. If you cannot agree to the sentence for the defendant as to first-degree murder, your verdict will be as follows. Quote, as to count 1, we, the jury, are unable to affix the punishment. Close quote. You, the jury, have found the defendant guilty of the crime of attempted murder in count 2. You must now decide whether to impose either a sentence of life imprisonment in the custody of the Department of Corrections or life imprisonment in the custody of the Department of Corrections with the possibility of parole. The court instructs the jury that you should consider the following factors in making your decision. 1, the defendant's chronological age. 2, the defendant's family and home environment. 3, the circumstances of the homicide offense. 4, the defendant's incompetencies associated with youth. And 5, the defendant's possibility of rehabilitation. The court instructs the jury that when all 12 of you reach and agree upon the defendant's sentence for attempted murder, you shall return the sentence in one of the following forms. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections, quote, as to count 2, we, the jury, sentence the defendant, Carly Gregg, to life imprisonment, close quote. If you agree to sentence the defendant to life imprisonment in the custody of the Department of Corrections with the possibility of parole, your verdict will read as follows. Quote, as to count 2, we, the jury, sentence the defendant, Carly Gregg, to life imprisonment with the possibility of parole. Close quote. If you cannot agree to the sentence for the defendant as to attempted murder, your verdict will read as follows. Quote, as to count 2, we, the jury, are unable to affix the punishment. Close quotes. All right. First closing by the state as to sentencing.
Have children, they say. It'll be
Mr.
fun,
Bale,
they say.
7.5 minutes. You wish a 2-minute warning or a 1-minute warning?
1 minute is fine.
1 minute. You may proceed.
Ladies and gentlemen, you've been here for 5 days now. Over 5 days, we've heard about this terrible crime that was committed by Carly Gregg. You have to consider her chronological age. We can't change that. She's 15 years old. In the eyes of the law, we talked about this on Monday, Carly Gregg is an adult. You do get to consider her age, but that's not the only factor you consider when you determine whether or not to send her to prison for life. We'd ask that she be sent to prison for life without the possibility of parole, and let me tell you why. When you consider her family and home environment, ladies and gentlemen, by all accounts, the defendant has told you she had a loving home. She had parents that adored her. She had every opportunity, more opportunities than most kids. She was advanced in school. She had guitar lessons. They took her to equestrian therapy. They took her to counseling. She had the opportunity to have medication. Nothing was enough for her. She still committed these heinous crimes. Nothing. Her home life was a perfect home life. When we talk about these factors in Miller, that usually comes up when we talk about these defendants that have been grown up on the streets when their parents weren't present. Now, did Carly have a dad that she didn't love or had problems? Absolutely. But ladies and gentlemen, that is not enough. That is not enough for her to be able to walk the streets. She murdered someone. She attempted to murder her stepdad. Her family life and her dad being on drugs is not enough. The circumstances of the homicide, I don't have to tell you that. Y'all just lived it. You watched it. You saw those awful photographs. You even watched that terrible video. We listened to Ashley Smylie's last name. We heard from Heath Smylie on that 911 call, the desperation. He said, help me. Help me. Ladies and gentlemen, those crimes were awful. She has shown zero remorse. Zero remorse for what she has done. Let's talk about her ability to rehabilitation. The defendant's own expert during the guilt phase of this trial said, you know, she's on this medicine, she's fine. But if you believed that, ladies and gentlemen, you would have believed that she was having some disassociated spell at the time of the crime and that she's continuing to have these disassociated spells. And obviously no one's buying that, right? We don't know why she committed these crimes, but we know she did. And we know that she is a danger to society. If she is given the possibility of parole, no one in this room knows how long she will stay there. We cannot guarantee she will stay there 1 year or 10 years. We have no control over that. Ladies and gentlemen, we watched one of the most heinous things that I believe most of you will ever see in your life. Please do not let this lady have the possibility of parole. If she were paroled, nothing would stop her from walking into a school. Nothing would stop her from walking into a shopping mall. Nothing would stop her from walking into the grocery stores. Nothing would stop her from being in the movie theaters. Ladies and gentlemen, she is dangerous. She may look like a little girl. They may have said she's sweet little Carly, but unfortunately, we all know that that's not true. We will ask, and I will ask you again when we stand back before you, that you sentence Ms. Gregg to life in prison without the possibility of parole for both the murder of her mother, Ashley Smylie, and the attempted murder of her stepfather, Heath Smylie. Thank you.
He seriously went there with the what's to stop her from walking into a school, knowing that's a hot button issue in the world today.
How much of a warning would you like, Mr. Camp? 2 minutes. 15 minutes total.
Thank you. I'm gonna have to tell you, this is probably the most difficult thing I've ever had to do.
Well, that's because you're a freaking DUI attorney.
I respect your jurors and I respect your verdict, and I totally understand that. And now I'm in front of you. Carly Gregg, this happened. She's 14. She's 15 now. Her family's sitting. Her grandparents, which are Ashley's mother and father, have been supportive during this whole process. Heath Smylie, who's the victim in this case, he has been supportive. This is a family that's been torn apart because of this.
And whose fault is that?
This is extremely, extremely difficult on on all of them. And I know the state is up here saying that she's this heinous individual. And you've heard a lot of testimony that that's not who Carly is. You heard the counselors, Ms. Kirk. She couldn't believe it happened. Nobody knows why it happened. You have the opportunity to not make this worse on the family. You have three options. You can do life without parole, you can do life with parole, or you can let the judge make the determination. In this case, we would ask you to let the judge make the determination. We don't want you to give her a sentence for life in prison. Life in prison is life in prison. That's it. 14-year-old. She can come out of this at some point. And you were hearing she can walk out of here in 10. We don't, first of all, we don't know. Usually it's a lot longer than that. I mean, a lot longer. So, I don't want you to, go back in that room and think, oh, if you come back and say she gets parole, it's not a short sentence at all. We would ask you to allow the judge to make the sentence, because the judge understands. I'm not saying y'all don't. I mean, you don't have the ability, so don't get me wrong on that. But he knows, and the court knows, what we're actually looking at with times. And so please, in this situation, please let the judge make the sentence in this case.
Hey, Heidi. Hey, Robert.
Final closing on behalf of the state.
Ladies and gentlemen, Mr. Camp is right. We may never know the reason why Carly killed her mom and attempted to kill her stepdad. And for me, that's even scarier than knowing why. Because if we don't know why, what's to say it won't happen again? We don't know. It is terrible for the family. The family has my sympathies, absolutely. I cannot imagine what any of them have gone through. We talked in voir dire about how sometimes the victims cooperate with the prosecutor and the prosecution, and sometimes they don't. We don't always know why. But I know this. My office represents the citizens of Rankin County, and my office is asking you to please sentence Ms. Gregg to life in prison without the possibility of parole.
Ladies and gentlemen of the jury, you've received you've heard the arguments. I'm going to ask you, I'll send you back the instructions. I'm going to ask that you retire to begin your deliberations. Everyone remain seated while the jury exits.
That's a good question. Here's my other question. Did the defense attorneys really believe the line of crap that they were spewing? Because the jury didn't buy it. And I can understand being sad for your client, but at the same time, your client is now a convicted murderer.
The evidence. Yes, sir. All right, if you would take those to them. All right, we'll be in recess till such time as the jury reaches its verdict regarding sentencing. If you want to. Well, there is that. Guilty on all counts. I do feel for her. She is only 15 years old. That is going to be a long life. But at the end of the day, she didn't have to grab the gun out of her mom's room. And I was watching the Law and Crime chat during the recess when the jury was deliberating the first time. Some of them people are like, did you even watch the trial?
Like, did you even watch the trial? There was people that were like, the Prozac is what did it to her. She wasn't even on fucking Prozac, people. Like, like I mean, it's one of those things. Yeah, I'm like, I don't know. For her family to be torn apart by this, hey, it doesn't seem like her family gave two craps because none of them testified on her behalf. None of them said, well, she never told me this. She talked to me about everything and she never told me any of this. Or, you know, she told me this all the time and I told her mom and her mom didn't do anything. Like, nobody, guilty on all counts. Yeah. So now the jury is back doing deliberations for sentencing phase. In Mississippi, the jury gets to do the sentencing based on the statutes. And if they can't, that's when the judge steps in. Instead of just the judge doing it all in other places, the jury gets to say. So, I mean, yeah, she should have taken the plea deal. 40 years. I mean, she'd be 65 or 55. Simple math. I like math, but math doesn't like me, apparently. But she should have taken the plea deal. Yeah, so now they life with or without parole. And I was I was thinking about what we were talking about the other day about like about hold on, gotta fix something. There we go. About the plea deal, and they were gonna drop counts 2 and 3. So I don't think so, because of the fact that she was found competent and sane. Maybe if she would have had any sense of, or there would have been anything actually involving she's not competent, then maybe it would have to be like that, or she has some more serious, you know. Yeah. Guilty, no parole. I can't say, I mean, I understand that's a difficult decision to make, and I'm torn based on her age, but at the same time, yes, I agree with, and yeah, she killed her mother, attempted to kill her stepfather, very cold and calculated is so accurate. That video, I mean, that video did it for me, because you heard, and the prosecutor, Katherine, is my new favorite. She did not, this was not she had, you know, a history of violence towards her mother. This is her mom pissed her off, and yeah, and I'm all for grown up crime, grown up time. You act like an adult and you want to be an adult. And everybody knows I'm all for gun safety, teaching kids how to shoot safely and use pew-pews and fire, you know, all that safely. My mom had a 38 under her pillow when I was a kid. I never once thought about going and using it just because. Like, it's, but I'm all for the grown up crime, grown up time. I'm torn on anything for parole, but like, she was calculated. Like, what initially made me think that she was calculated was she looked into the kitchen, peered around the door to see if her mom was in there. Like, she literally looked in there to see, is she in there? And when she knew she wasn't in there, that's when she went back to her bedroom. So like, I have a very very hard time ever. Like, you know what you did. Like, you can't, and I hate people who hide behind mental illness as a reason why they did something. Like, especially when you only have anxiety and depression. And I'm not saying anxiety and depression aren't real. I deal with them every day. However, just because you have anxiety and depression does not make you immune to consequences of actions. I don't like the people who hide behind mental illness and say, well, do we need to get rid of stigma in this country? Yes. Is it a huge problem that we need to deal with? Yes. However, letting people get away with heinous acts because they have a diagnosis is bullshit. Even my bipolar people, even my bipolar people know right from wrong. Even psychopaths, they don't care about right and wrong, but they know right and wrong. And that's how they manipulate you. I feel like she was a huge manipulator. She manipulated because she was cool, calm, and collected from the time that she unalived her mom to the time her stepdad got home. And then when her stepdad got home, it was, we had there was pew-pews all over the place. When I moved in with my aunt and uncle, there was a 12 gauge behind my bedroom door. Never once did I ever not once did I ever go, oh, I think that might be like my mom attempted suicide when I was 16 years old. Like, never once did I think that I would walk on eggshells around her. And she knows this. This is not a secret. I would walk on eggshells around her after that because I didn't want to make it worse, or feel like she would do it again. But that doesn't mean that when she got mad at me that I thought it was like, oh, I have to get rid of her or something like that. It was a permanent action for a temporary thing. So your mom found weed pens, or your friends told her you were smoking weed. Like, worse things have fucking happened. Like, my mom found cigarettes in my room at 14, 15. Like, she was pissed, yes. But guess what? Yeah. It was pretty quick. I would highly recommend going back and watching it because she actually showed real emotion for the first time, and everybody who saw her emotion on day 1 or 2, and her crying, compare that side by side with today's tears, and it makes day 1's tears look even more like complete crap. So it's just, yeah. While we are waiting for the verdict watch for the sentencing phase, which I don't think this one will take nearly as long as the first one, even though the first one was short, straight to the point. I am going to Orange County Clerk's website, and we are going to read through some of the documents. We don't have time. Well, my assumption, and I could totally be wrong because don't think I've ever done a case where the jury does the sentencing. Regardless of the psychiatric history and all the meds, there's a core personality in each of us. Her core personality is this and will always be: a life sentence without parole will protect society. I can't say I disagree. I am going on to the Orange County Clerk's website, and I'm also going on to my social media. One of the reasons I was on my computer when the verdict came back is I was updating Baby Squid's Amazon list because somebody put in my head that I should make her a list. That way, if you feel the need to support my channel, but you don't want to support me, you can always support her because she's more important than me. And that's not her saying she's more important than me is not a joking thing. She is more important than me. When she was born, Mr. Squid and I became less important. Okay, Flash fan, I'm looking at the article. Okay, and I have not looked at anything. Oh, there's a note from the jury. I have not looked into anything that we I am going to work out today because I have been slacking. I admit I've been slacking because I've been on my damn computer the whole day for this week. So I have to come up with a better thing. And Mr. Squid and I are going on vacation, and the little are going on vacation for the weekend of Halloween. So I really need to bust my butt because we're going to a place where I might have to squeeze my butt into a swimsuit, and that's never going to be a fun time. A couple of days ago, he texted me when he was at work, and he was like, "How do you feel about going on vacation?" It's like, where the F has this been for 3 years? The last time he took a vacation with me was Christmas of 2020. So I am opening up the oh shit. Okay. I am going to, let's see. I'm trying to figure out the best way to do this where I'm going to pull this out so I can see it. There we go. So I'm going to lose sight of the chat for a minute. I apologize. I love you all. But I need to be able to see what, well, there we go. I have 2 monitors, but I'm still trying to figure out the best way to do certain things. And the only reason I have 2 monitors is because I got an early birthday gift from my father. So, this is Sarah Boone's apparent expert. There we go. Dr. Michael Birkland, former medical examiner, arrested for storing human body parts in Florida storage unit. Just the title alone. Just the title alone is like, excuse me, sir? I don't know what to say about this. And I'm assuming from what I've been told, this is that would be my guess too. If we give her parole, how long is she? How long is it going to be? And I'm assuming they'll give her parole if she's not going to be eligible for 30 to 40 years. If she's going to be eligible for parole in like a year or 2, I don't think that, or on her 18th birthday, I don't think that they will give her parole. But that's just my opinion. I could be totally way off base. My opinion is based on how long it took them to come back with a verdict the first time, and also how long and what I feel about this case. The article was August, well, the event was August, September 10th, 2012. So this article is not new. But I guess this is who Sarah Boone's expert witness is going to be. Florida police arrested former medical examiner. Oh, Michael Birkeland on Friday, and they are back in the courtroom. So I will read that article a little later. Because
All right, the bailiffs inform me if the jury has a question. Jury's question is, what is life in prison without parole? Question mark, ears wise. Attorneys can approach, look the note. All right, anybody need to review any further?
No, sir.
All right, I'm going to mark the C next to number for ID purposes only. All right. Well, the truth of the matter is that the truthful answer to that question is nobody knows. However, typically all the court can say is something to the effect of, you have received all of the evidence and instructions in this case, please continue your deliberations. I'll hear arguments from the state as to response
No argument.
by the defense.
No argument, Your Honor.
All right, I'm going to ask Ms. Butler or Ms. Eaton to write that out. Y'all know my handwriting's bad.
I actually believe these are real tears from her.
All of the evidence and instructions in this case, period. Please continue your deliberations.
You can have empathy for someone, but still believe that they should be behind bars for a long time. Those two things are not mutually exclusive. And just because I feel for her and her age does not mean that I think that she should get parole.
All right, I'm going to ask counsel for both sides to approach one more time. Look at the note, make sure you agree that's what it says. Any objections by the state?
No, sir.
By the defense?
No, Your Honor.
All right, I'm going to ask Ms. Butler to make a copy of that. I'll mark the copy C next to number for ID purposes only. The bailiff will take the original back to the jurors. I'll take the copy. The copy of the note will be marked C next to number, C4 for ID purposes only. Mr. Bailiff, you can take that note to the jury. We'll be in recess till the jury reaches a verdict.
I mean, this outfit's not half as bad as the one she wore to her, one of her pretrial hearings. Let me look at my my channel dashboard, my studio, where yeah, in the video she was wearing typical jeans and a band t-shirt. I think she was wearing a Nirvana t-shirt, which is insulting to Nirvana, but that's beside the point. We're gonna go to, I am looking at my Carly Gregg playlist because there was one video her competency hearing, I think. Yeah, that's what I'm thinking. But I believe these are real tears. I do. These in comparison to Monday are real tears. However, I don't think that they're tears for her mother. I don't think they're tears for her stepdad. I think they're tears for herself. I think they're tears because of what she did. I think it's the competency hearing, which I think it's the competency hearing. Oh, I clicked on the wrong thing. I clicked on details instead of a view on YouTube. And if you want to see exactly what she was charged with and the details of what she is charged with, I have a 5-minute video just reading the competency. So I will keep an eye on deliberations. I will pull that tab out again and put it over here. Shrink it down so that I can see it, but I can see y'all too. Yeah, those are tears for herself. And every teenager gets mad. Every teenager has an attitude. However, and I'll share this tab instead. And this is weird of me watching myself. I don't like watching myself. It's creepy to me. It's very creepy. I don't like hearing my voice. I don't like any of that. So we're gonna play this.
There was an amended motion
Hopefully
by the state
you're up.
that you just referenced. I will make that motion. Document 111, an amended motion for mental evaluation and adult analysis. All right. So the state of Mississippi is asking that Dr. Gugliano be relieved from her obligation to perform an adult analysis.
Yes, sir, Your Honor, that's correct.
You want to hire somebody else to perform an adult analysis.
Yes, sir, Your Honor. Dr. Jason.
Okay. What type of doctor is Dr. Jason Pickett?
He is a forensic psychiatrist. Also, he has did his residency in emergency medicine as well.
Have you informed him of the trial?
Yes, sir, Your Honor.
All right. Anything further from the state?
No, sir, Your Honor.
Response by the defense.
First of all, Your Honor, when Dr. Gugliano went and did the, I guess, the competency hearing, she got halfway through her evaluation on the they were just supposed to continue. So we don't understand why they're having to switch to somebody else when that person evidently was qualified to do it and was doing the.
Yeah, this is what they dressed
Based
like
on
at her
the brief
competency
amount that we talked about what was going on with Ms. Gregg around the time of the alleged offenses and the months leading up to them. Her medications were switched, and so there may be a question of withdrawal from medications and how those may have interacted. So it's the fact that side effects or withdrawal symptoms from the medication could be relevant to mental state. That is my opinion why I'm not the best expert to do that type of evaluation.
And as you sit here today, you can't say, Dr. Gugliano, whether or not there were any withdrawals or that could actually be an issue.
No, I cannot. That's outside of my scope of expertise.
No further question.
Other things.
No question.
Is there somebody at Mississippi State Hospital that could have,
this is her.
whose area of expertise is that line with that?
We're gonna stop sharing that. Okay. We're gonna stop sharing that because of, well, you know. But you can tell who was here back in July. I think this was August 1st that I covered this. So it was a little bit of time ago. But there's also her pretrial hearing. One of them. I think this is the one where they completely dressed her in, I believe this is the one where they completely dressed her in a what, where they were trying to make her look like a baby. It's creepy to me, but I will skip ahead because nobody needs to see my intro. But there's me and my Kim on. Oh, nope, she's wearing the same dress in this one. There is one that I covered, and I don't know if it's actually in my playlist. Look at, Look at the top chat. Roland, you were like, still a weird outfit in my opinion. Oh, yeah, the hair in the RBF. No, there's one that's worse. Christy, there's one that's worse and I'm looking for it. I just have to actually I just have to look for it in my, because it's not in my thing. I have to, it's kind of one of those like, I'm having to look for it in my, no, the updates is when I was reading through the documents. Okay. Some of these videos, I don't know what they are because like when I say updates, it's like, okay, what am I updating? There's one that was like, say what? When she was, and I gotta find it, but it might have been on a WTF Wednesday, but it was like the worst outfit I've ever seen from anybody any trial I've ever covered, or like any trial. July 29th. Okay. Let's try this one. Oh no, this one she's in prison garb. This was back in July. So
grandparents who were able to tell me, and I was able to get someone from the detention center on the phone to handle it.
Chandler, she being housed in the general population?
She's isolated, sir.
She's isolated.
I think she's just more prison crap.
I don't tell the sheriff how to run his jail, but I believe our sheriff has enough good sense not to put this young lady out in the general population at this point. Court looks at the following factors: age of the juvenile, she's 15 years old, physical and mental maturity of the juvenile. Court heard at previous hearings, she's a very intelligent juvenile. Present mental state of the juvenile, including whether or not the juvenile represents a risk of self-harm. There was prior testimony regarding self-harm of this particular juvenile while she was not incarcerated. However, the court's heard no such danger while she is incarcerated. Nature and circumstances of the alleged offense do not weigh in favor of the defendant.
Yeah, Flash fan, I completely agree. Just because you're being charged as an adult doesn't mean that I think you should be in an adult facility with other adults. And I did, yeah, I mean, I hate to be like the make judgments before the trial, but the fact that her stepdad survived and literally can testify that she's the one who shot me, and her friend that came over, she left 2 witnesses, her friend that came over and her stepdad. So yeah, her body language is like giving me psychopathy vibes. The fact that she's just, there's no like, yeah. So, and that could be the fact that I believe that she's not showing any emotion, could be the fact that she's newly on psych meds, which does change your personality.
Now that we know it was Abilify.
Yeah, I get it. But there's also like all these pretrial motions have to occur because you can't establish at her trial that your defense is going to be insanity. Unhung Hero, I'm really torn too. It's one of those things of like, and it's a case by case basis for me, but like when you are charged with unaliving someone, that's a very adult action to take. I mean, no adult should do it either, but like,
you can see you can see the fact that I'm like adult. I have a better phrase for it now. It's adult crimes, adult times. Like, yeah, but there was one hearing that, I wish I could find you that where the judge got snippy with the defense.
Photos of them, they
His
do
judge
an impartial
Arthur was
jury.
not.
But moreover,
Right.
the jurors
Bullshit
have a
from the
right to
start.
be able to make their deliberations and render a verdict without having to be worried about the scrutiny they're going to face from coworkers, employers, family members, and neighbors, people in their church. And I think that gets very hard to do when you're in a highly publicized hearing and everyone's looking at you and knowing that you're a juror who didn't vote yay or who didn't vote nay. And it comes back down on them and it affects their public lives. Moreover, for Carly's sake, in this country.
So this was where the judge was talking about, or they were discussing whether they should be, there was motions to keep it secret and to not have cameras, which was interesting that the defense didn't want cameras in the courtroom, and then they were the ones who went to the media and did interviews. It just strikes me as a little bit of hypocrisy. It's one of the other reasons that I haven't liked this defense team from the start. In the UK, she would be in a young offenders unit while on remand to serve her sentence till she ages out. Then she would be transferred to an adult prison or secure mental health facility. I honestly don't know what happens here. Especially because it's in Mississippi, I really don't know. Because Mississippi seems to be a FAFO state. They don't have the bandwidth to give a shit about things that don't matter. But I seriously wish I could find that he was here earlier. Yeah, you can look at who it's weird watching myself. It's so weird. And I'm just trying to find that really, really bad outfit and I can't find it. Like, I just can't find it. But here's, let's go back to this.
Yeah, I figured it was.
For the board, the
Fan.
defendant's motion to exclude the public and media, NBC number 12, the defendant's made a motion to exclude the public and media, NBC number 35. The court's read and considered all the motions and responses, including Court TV and Gray Media and Incorporated PDA, WLBT's motion to intervene and oppose, NBC numbers 19 and number 56. Primarily, the defense raised 99-43-101. There's a one-sided case of that. That's Pitts versus State, which was tried in this very courtroom. In that case, it was the witness was a victim of sexual assault. If I remember correctly, it was her father. Courts looked at 99-43-101. In particular, of course, looking at subsection B, subsection I. It says any criminal hearing, criminal trial, or other criminal proceeding in circuit county court in which a child testifies as a victim of a crime or as a witness to a material issue.
I would not agree.
Right. The right to an open and public trial is a shared right. It's a shared right of the accused and the public, and the common concern being fairness. This court is required to determine whether the rights of the accused override the qualified First Amendment right of access by the media and the public. First, this court would note that the very first amendment of the U.S. Constitution is the fact that government shall make no law abridging the freedom of the press. The time-tested manner of testing witnesses' statements to require a public statement under oath facing penalties for perjury. This court is being asked to exclude the public. First, this court would note this is the public's courtroom. People of Rankin County in this courtroom, not this judge, nobody else. This court's not going to exclude the public. Second, the court's being required to exclude, is being asked to exclude all media. What the court has basically heard is that arguments are that the family's tragedy is not fodder for public entertainment. However, it's a terrible fact of humanity. I don't know why people are interested in cases sometimes, but they are. Back to Oedipus. The Greek story to William Shakespeare and what the 16th century, people have been interested in jury trials. in this country, we have a media, we have the press, so things can't happen behind closed doors. As far as the impact on the family of the victim, this court often is faced, the defense counsel doesn't want the family having an impact on the case, because if the family's calling for sentencing, for blood, then the defendant doesn't want blood. However, when you have a family that's calling for mercy, I don't know what to do in this particular instance. However, it can't be done behind closed doors. Just can't.
I like the
heightened
judge.
scrutiny on potential jurors. The interveners have agreed, and this court will order that the jury list will not be released. In this case, it will be placed under seal. If any potential juror at the close of this case wishes to be identified, that individual juror can step forward on their own. However, if an individual juror does not wish to be identified, then the list of jury will be sealed, and that juror will not be identified. Further, the rules of electronic proceeding, the Mississippi rules for electronic photographic coverage provide that the jury is not to be videoed in any manner. There's not to be any still shots of the jury. The court will not allow the cameras in during jury selection. Bottom line is the court's not going to allow the jurors to be identified. The intervener has agreed to that. As such, that is an accommodation this court's making to alleviate the defendant's fear. However, as far as live streaming conversations of the defendant and her counsel, the rules specifically provide that there should be no audio recording of the defendant and her counsel. The court's not heard any evidence that that's happened. In fact, the court has heard exactly the opposite of that. Additionally, this court's taken some steps. The court has told the bailiff that a room behind the courtroom will be available to defense counsel and the defendant during breaks, where they can sit, they can discuss trial strategy, they can have those conversations. Anything that a camera could pick up, a jury could pick up visually during the course of the trial. However, the court will impose certain limitations on the press in regards to audio recording of statements between counsel and between defense counsel and a client and the defendant. All right.
Even back then, he was very protective of his jury in his courtroom. I like this judge. He's no nonsense, but you could see then, even back then, he was not happy with certain things. Oh yes, and by the way, this video only has 20 likes on it. Like the video that we're watching. If y'all could go over there and shoot it a like, then drop a like on it. Yeah, trust me, it's weird for me too. It's very bizarre for me to watch myself. I'm like, oi, but I was skinnier in that video. Yeah. Judge Dewey Arthur. That's the most Mississippi name you're ever gonna get. Let's see what Bridgett Todd had to say.
Forwarded the email where I sent it to the state's doctor to Katherine.
Okay. All right. This wasn't noticed in time for the court here today, but I'm forewarning both sides. I'm going to hear this motion. You need to renotice it for the first day of my term. Instead, Mississippi made a recommendation in this case.
All right, we have not made a recommendation, and as to the
Yeah.
requirement, we were trying to allot as much time for compliance. And can we get some clarification? Did they oppose the subpoena?
She's already been on camera, so what's the difference between when she's testifying on camera and her being at the defense table on camera? It's the same thing to me.
We do not
Trevor.
oppose the subpoena.
All right, bring the order. Grants.
Weird.
It's 10 separate orders, Judge, since they were filed separately.
Weird. It is so bizarre. Look at Katherine's legs. Spicy with that short skirt on. All right, we're gonna stop sharing that. Court TV has some nice music on their videos. Yep, that's Court TV. Let's go and bring this back. Thanks. Appreciate it, Cynthia. It's one of those things of like, okay, Court TV, I like you, but we gonna have to mute you because you got some elevator, not good elevator music. If you're gonna do elevator music, don't make it sound like Court TVs, please. If you're gonna do elevator music, make it sound worth it. All right, so while we're waiting, we are going to go through Sarah Boone's, the clerk of court website, because I have been so behind that I can't even. Flash fan, you earlier this morning, you told me what the last, there's been a whole lot of crap since I last looked at this. Yeah, I know I can like my own video too, but I hate doing that. Like, I don't know. I hate doing that because it feels fake. I don't know. I feel like I get it. It's like voting for yourself in an election. You can do it, but it's shitty. Yeah, I heard comments actually matter the most, but I could be. And on Twitter, likes don't matter. It's the retweets or reposts. I guess they're not retweets anymore because they're reacts. Just, yeah. I left off in the first motion to rely on battered spouse. Jesus. Sweet baby Jesus. Okay, I came home from Wisconsin on September 6th. I'm so like, look at all these. I know I missed a lot. I think I left off in the notice of appearance. I'm gonna open this and see what it is. Notice of appearance of her second attorney. And I do have the Mississippi courts stream up in a different window so I can see it. And if anything changes, we will instantly go back to that. But I have not kept up on this in a long time. And I am, yeah, well, I'm looking because I read the notice of appearances, the motion to continue, and I believe his first hearing on the 3rd. Hoi, oi, oi. Did we read the motion to object, or did we read Sarah's last I appreciate people's honesty. And like when people do comment and they comment like constructive feedback, like, hey, I would appreciate it if you would not try to talk over the judge or pause it when you know, I learned from that. I appreciate comments with constructive feedback. I don't appreciate the wannabe YouTuber stop talking so much when you're on a fucking commentary channel. Like, sorry, this is a commentary channel. I give you my damn opinion. Like, we go through it together and we talk about it, but like, I give you my opinion. And the people that come through and go, stop talking so much on a commentary channel. If you don't want commentary, go to Court TV or go to Court TV's or Law and Crimes pages and watch it there. That's my only thing. But like, if someone gives constructive feedback of, hey, when you do this, it's kind of hard to hear, or I don't like this, Totally good with that. The thing after the September 3rd hearing. Flashman, I am so glad you keep up with this because this is why I'm so glad you're here. One of the many reasons I'm glad you're here. But yeah, I think I read the notice of filing for the inmate record from the Orange County Jail on the 3rd of September. So we are going to read Sarah's I don't think I read Sarah's last motion as a pro se defendant, but if I did, oh well, we're doing it again. This is I believe Sarah's last pro se motion. Comes now the defendant, Sarah Boone, by way of pro se, respectfully requests this honorable court that my motion be heard as to my reasons why I'm objecting to the state's evidence against me, and to exclude or limit the following particular items attempting to be admitted in my criminal case by the state. Objections are for digital content specifically only located on the USB jump drive titled as 2020 CF, her case number, digital discovery compilation, which was submitted to defendant August 9th, 24. Objections by defendant are as follows. Suitcase videos, 3 items. These files were obtained from my personal cell phone. There are no videos located in this folder on the jump drive. Photograph of suitcase, audio 2 minutes, 3 seconds, audio 22 seconds. I think I read this, but I think I read this to myself. I didn't read this on a stream. It was very hard to stream at my dad's house because I only had my laptop, and I got used to 2 screens and being able to see the chat and StreamYard on one and read the on the other. And I got a little bit shall we say bougie. So I found it very hard to stream when I was at my dad's. Like, I appreciate you. And I appreciate everybody who hangs out with me all the time. Like, I love you guys. You're awesome. And the haters too. You annoy the crap out of me and I call you out, but you're still fun to fuck with. Sorry. Lack of authenticity. There's no one to testify that picture and audio are the same as the scene was at the time the audio was recorded and photograph taken. Okay, does she not know about data extraction from a phone? Oh, shit. Sarah, you give me a headache. I don't know which worse, Sarah as a pro se defendant or all the motions and the crap that her new attorney is trying to pull. I don't know. It's all shady to me. The prosecution fails to establish authenticity in any of the 3 items submitted. Florida statutes 90.901, supporting case law, Cooper v. State, Florida 4th District, 2010. Oh, Sarah, you put me to sleep. Potential for unfair prejudice. I believe that the singular reason I appreciate that. And remember, only hit it once, not twice. I rarely, if at all, like my own videos, Cynthia. It's weird to me to like my own video. I don't know. Potential for unfair prejudice. I believe that the singular reason to utilize this audio is for the state to heavily prejudice the jury against me based on my statements in the audio to George Torres. Well, guess what, Sarah? Guess what? Their whole job is to prove that you did it, and your words prove that you did it. Your words, your video that are, I guarantee you the state can go, yes, this was taken on the night of February 24th or February 20th. She was arrested the 24th. One of those days. Prosecution's evidence is more prejudiced than probative. Your own statements on the night that while he was in the suitcase are prejudice. Make it make sense. Violation of Fourth Amendment rights, which I swear she puts in every single one of her motions. If not every single one, like every other one. Violation of Fourth Amendment rights, unlawful search and seizure. This audio was obtained by unlawful search and seizure of my personal cell phone. She was arrested the 20th. Okay. I believe something was the 24th. I can't remember what though. Ugh. So she puts supporting case law, map v. Ohio. And some of these things that she's complaining about, I'm truly, truly sure that if they were real issues, one of her prior attorneys would have brought that up. Some of the things that I heard, and I haven't seen them, because when I am doing a trial, when I'm done with the trial for the day, like, I don't want to sit on the computer at all. So, like, I'm barely in anybody else's chat. If I am, I'm on my phone. Because I'm literally not wanting to be anywhere near YouTube. And I'm pretty sure if the Fourth Amendment violation was a problem, or the Miranda right issue that I heard yesterday, was an issue, it would have been brought up by a prior attorney, since she's had a bunch. Some had to get out for other reasons, but not everybody had a inability to defend her due to her attitude. But some of the people that defended her, I'm pretty sure if this was a problem, they would have brought it up. I know I would have. Body cams, 4 items. Death investigation videos, 1309, 1322, and 1442. Lack of authenticity. She's going to have a lack of authenticity in every single one of these things. All the body cam videos obtained from the uniformed officers on the date of the incident are timestamped and documented incorrectly during the entire use while at the crime scene. I don't think that's true. I don't think that's true at all. In fact, I think that's not accurate at all. Hi, David. How are you? Welcome to my stream today. We are just having a good old time waiting for the sentencing phase of jury deliberations. They came back with pretty quickly, an hour and 57 minutes, I think, with a guilty verdict. And remember, they ate lunch during that time, and they had to fill out the jury forms. So that was not a very long deliberation at all. Now they get to choose between life with or without parole. So in the meantime, we're reading through all the documents I've missed in the Sarah Boone case. This was her motion on the 5th of September. So I'm a few weeks behind. But we're catching up. Violation of best evidence rule. The state fails to provide the best version of this evidence. Under the best evidence rule, the state has not provided true and accurate video evidence, and the defense moves to exclude these body cam videos. Florida statute, section 90.952. Yeah, this is her last motion is pro se. Supporting case law, McCoy v. State. I keep checking when I see movement on the camera, somebody walking across it, I keep turning it on. I muted it because Court TV has this god awful hold music. It makes Megan's hold music look like a Grammy winner. And not that Megan's hold music is bad. I have a copy of that because it calms baby Squid down when she's throwing a temper tantrum, which I'm really hoping she's asleep. After we get through this motion, I need to go check on her because it's quiet. She might have passed out on the couch because that's where she was the last time I checked. Violation of Miranda rights. The body cam videos recorded me making statements and providing information prior to me giving any Miranda warning. These are illegal interrogations and a violation of my Fifth Amendment rights and should be excluded under the exclusionary rule. Supporting case law, Miranda v. Arizona, Edwards v. Arizona. Defendant's interviews, 1 item. Sarah Boone interviewed 2. Lack of authenticity. Shocker. This interrogation video has no timestamp throughout its entirety at 2 hours, 6 minutes, and 3 seconds. Okay. Yeah, I'm hoping she passed out because she was tired before and I was going to get her down for a nap before I was going to come back for the verdict. But the verdict came first. And she's been fighting naps lately. So if she doesn't take a nap, I'm not going to be shocked. Mr. Squid had to leave for work a little bit earlier than he has the last 4 days. But he also doesn't have to work. Oh, we're back. We are back. How long, with or without parole? I should do a poll. Let's see. Yeah, Nat Bohr is 24. Let's see. And I will be right back. I have to go check on the little.
I've been told that the jury's reached a verdict as to sentencing. I don't know what the jury's verdict is. As I said before, they didn't ask for the job, and we will not praise their verdict, and we will not condemn their verdict. Any outburst, positive, negative, whatsoever, will be direct contempt of court, and you will serve 30 days in jail for each outburst. If you cannot control your emotions, you should leave the courtroom at this time. Mr. Bailiff, please bring in the jury.
Definitely a PDF vibe. She wasn't quite getting into trouble, but she was close. This is mine, please. Oh, yes, we are sleepy. I want to say 40 minutes, 30 minutes. Not very long at all. I can't say I actually looked at the time when they went back. Yeah, he does give some creepy vibes. Not gonna lie.
Now, I see you're holding the paper. Would jury been able to reach a unanimous verdict? Please hand that to the judge. All right, the verdict appears to be in proper form. Ms. Gregg, if you and your attorneys would come to the podium. The verdicts read as follows. As to count one, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. As to count two, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Please be seated. Ladies and gentlemen, just as I did with the verdicts of guilt, not trying to be rude. It's the quickest way we can get it done. As to count one, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, sir, is that your verdict?
Yes, sir.
Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict? As to count two, we the jury sentence the defendant Carly Madison Gregg to life imprisonment. On the front row, ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Ma'am, is that your verdict? On the back row, ma'am, is that your verdict?
Yes, sir.
Ma'am, is that your verdict? Sir, is that your verdict? Ma'am, is that your verdict? Ma'am, is that your verdict?
Yes, sir.
Sir, is that your verdict? And sir, is that your verdict?
Yes, sir.
Verdict appears to be in proper form. Ladies and gentlemen, the jury, please exit. I will be there in just a moment to release you, okay? Everyone remain seated while the jury exits.
Well, life in prison. This is why we don't screw up our lives at 14 years old. This is why whenever you feel like you want to unalive somebody, you step back, you take a minute to think about your actions.
Ms. Gregg, please come to the podium.
I think we're going to find out right now.
Your sentences will be as follows. As to count one, the jury having fixed the verdict at life imprisonment, this court will sentence you to life imprisonment. As to count two, you'll be sentenced to life imprisonment. As to count three, you'll be sentenced to 10 years to serve. You'll be required to pay court cost fees and assessments in the amount of $431.50. Ms. Gregg, regarding any appeal of your judgment of conviction and order of sentence and in accordance with Wright v. State 577, Southern 2nd 387, the court wants to inform you that pursuant to Rule 4E of the Mississippi Rules of Appellate Procedure, the notice of appeal required by Rule 3 of such rule shall be filed with the circuit clerk within 30 days after the date of the denial of any motion for a new trial or the date of imposition of sentence, whichever is later. Pursuant to Rule 4E, if you make a timely motion under the Mississippi Rules of Criminal Procedure for a judgment of acquittal notwithstanding the verdict of the jury or for a new trial under Rule 25.1, the time for appeal shall run from the entry of the order denying such motion. Finally, Rule 25.1 subsection C provides that a motion for a new trial must be made within 10 days of entry of the judgment, which includes both adjudication of guilt and sentence. Should you make a decision on the record to appeal, that decision will stand unless a written statement to the contrary signed by you and your attorney is filed with the court. Should you make a decision to waive appeal, that decision will stand unless you give written notice to the court and your attorney prior to expiration of the time in which you perfect an appeal. Should no decision to appeal be made by you, your failure to express a desire to appeal shall be considered a waiver of your right to appeal, and that waiver will stand unless you give written notice to the court and to your attorney prior to expiration of the time in which to perfect an appeal. Have you made a decision to appeal your conviction and sentence? All right. Court will be in recess.
Your Honor, clarification, I apologize. On the
Sentences will run concurrent.
Concurrent sentences. Yeah, I've been getting a weird vibe from him since he testified. Like there is some weird like obsession with, she's such a good kid. She's not a good kid. She killed your wife. sir. And she shot you. And like the prosecutor said, that was 6 inches from your head. I don't think that was intended to hit you in the shoulder. I think that shot was meant for your head. You got very, very lucky. And, well, guess what? This is what happens when you make permanent decisions. Like, I got nothing. Like I feel bad for her because she's a child. She's technically still a child, but you make grown-up decisions. You have grown up. Yeah, he never said anything about parole. So my assumption would be without parole. If I hear anything different, I will be sure to correct myself. But they didn't say anything about parole. And that's her family, but like people, you should have raised her better. Yeah. I will see if I can find one. Let's see. What is should it be local media? Yeah. And I honestly like have a good day, Roy. There's no emotion there because I don't think they were shocked. I think they are upset, but this judge was not this judge was not effing around when he said it's 30 days in jail for each outburst. Like so this is
we still wouldn't have knew.
Breaking the most important stories.
The court declares a mistrial in the matter of the state of Mississippi versus William Ervin Edwards.
The police, they screwed up the investigation because they really didn't investigate.
Breaking news that impacts you.
There we go.
Ms. Gregg, please rise and come to the podium, along with your attorneys.
You see her look at her family like they already know.
Proper form.
Like I looked at her during this.
We, the jury, find the defendant, Carly Madison Gregg, guilty of first-degree murder as charged in the indictment. Count 2. We, the jury, find the defendant, Carly Madison Gregg, guilty of attempted murder as charged in the indictment. Count 3. We, the jury, find the defendant, Carly Madison Gregg, guilty of tampering with evidence as charged in the indictment. Please be seated, Ms. Gregg.
Yeah, I looked at the
It can be hard to move.
The attorney, or I looked at her during that, but that time I looked at the no, the 10 years was the tampering with evidence charge. That was where the 10 years came from. They were 2 life sentences, which were not there was no talk of parole. So I'm assuming that they're without parole, but they will be concurrent. So in 10 years, her sentence for the tampering with evidence will be completed. So I don't think she's getting any parole. It's yeah, her goose was cooked pretty much. Have a good weekend, and I think I am going to get out of here. It's been a long week. Yeah. For a family that was so close and so supportive of her and all of this, nobody testified. Guilty on all 3 counts, 2 life sentences and 1 10-year sentence for tampering with evidence. And nobody seemed to mention parole. So I believe it's 2 life sentences without the possibility of parole. Well, the third count's not a parole. The third count's only a 10-year sentence, not a life sentence. So the third year is just, but the 10-year sentence is the 10-year sentence doesn't matter because of the fact that like she's yeah. Hey. Yeah, she should have taken the plea deal. I said that from the start. But thanks, Carly, for getting me monetized on YouTube because, you know, I got all my hours now and stuff. But yeah. Well, I'm still not monetized. I am waiting for YouTube to approve me. So hopefully my content is YouTube approved. Yeah. Who knows? This trial, in addition to Sunday's stream with Roslyn, got me about 700 watch hours. So we're almost to 4,000 watch hours. The plea deal was for 40 years. 40 years for the first count and dropping the second and third counts. So it would have been 40 years for first-degree murder, and that's it. So she didn't cry a lot, but she did cry, and it was genuine. And if you think, and if anybody thinks her tears on Monday or Tuesday were genuine, look at these tears today and then go back to the stream on Monday and look at those tears. There is a vast difference in the presentation of both tears. I believe that these tears today were real. I do not think that these tears were for her mother. I do not think that these tears were of any remorse. I think that these tears today were for herself and the fact that she is not going to be seeing freedom forever. She's gonna have her sweet 16 behind bars. So I don't know. I have to look at my earn tab to see. I have to look at my YouTube studio, and I'm just behind. No Taylor Swift concert. Yeah, not that, I don't know. She doesn't strike me as the Swifty kind, but anyway, I'm gonna get out of here. I'm gonna go try to get little one done for a nap because, you know, that's against our religion these days. I will be back probably on Monday. We will see what these we will see what we might go over Sarah Boone's hearing because we still haven't done that. Hey, General. Promise what? No Taylor Swift concert or the fact that I'll be back sometime next week. And I do have some work to do because if they do approve me over the weekend or tomorrow or whatever, I have to set up memberships and figure out how to do all that stuff. And I don't know. It's weird. I had to set up an AdSense account today, and that was kind of weird in itself. So let me go to my channel dashboard. Let's see. Content. Live. In options. Oh. control room. And I figured out how to go into my control room. I didn't have that option before. Or if I did, I didn't know it. So we are going to, it's one of those things of I'm looking at all options because I'm seeing what I can do. Customization. Yep, and I still don't have the ability to redirect people. Because I was told that was in customization and I can't see it. So Celestial Force, where have you been? I've been streaming this trial all week. I've been streaming this trial since I've been streaming this case since July. I believe the end of July was my first video. But have a good one. Cynthia, thanks for being one of my biggest supporters. I appreciate you. Oops. I've been streaming this trial. Like, I have a playlist that goes back to her July 5th competency hearing. So, Flash Fan, I appreciate you turning me on to this case. This is all Flash Fan. He sent it to me, I believe, at the end of June, and it was July before I got to it. But I will see you guys later. I appreciate you all being here as usual. Couldn't have done any of this without y'all. Have a great one. And remember, keep it petty.